This is ABC News legal analyst Royal Oakes welcoming you to Hinshaw and Culbertson's Insurance Law Program, where we discuss insurance and reinsurance issues of interest to industry professionals. Here's your host, the co-chair of Hinshaw's Global Insurance Services Practice Group, Scott Seaman.
Welcome to Hinshaw Insurance Law. This is part 2 of our 3-part series on cyber. On this episode, we're going to be discussing the rise in cyber negligence cases. There seems to be an increase in the number of lawsuits filed based on a company's bad cybersecurity practices, or in some cases based on advertising that their cybersecurity is sufficient when it turns out not to be the case. Joining us, in other words, backed by popular demand, is the savant of cyberspace, Annmarie Giblin. Annmarie is a partner in Hinshaw's New York office. And Annmarie, thank you for joining us again. I can't believe you're back for more punishment.
Thanks for having me again.
So Annmarie, it seems like there's a growing number of grounds or contexts in which a liability surrounding data is based involving negligence allegations. Can you give us an overview of what the cause of action of negligence is and the different types of claims that you're seeing?
Sure. It's really important to understand that as this is growing, it's becoming a regulatory risk and a negligence liability lawsuit risk. So just to address the regulatory first is that regulators now are actually coming in, and especially in the DOJ has a false claims act fraud unit that's going after government contractors who say they have a certain level of cyber security. And then in a breach situation or some other situation, maybe an audit, when it's determined that you don't have that level, or you're not doing the things that you said in your contract to do, that becomes a false claims issue. And that's a really bad day. And we're seeing that not only from the DOJ, but other regulators. Putting that aside, though, what we're also seeing is a really growing area of cyber negligence cases. And it's really coming down in 3 different ways. The first way is what we call physical cyber risk. So something that you're doing from a cybersecurity perspective actually causes a physical harm in the real world. Really bad day. So a great example of that would be the autonomous vehicles that we're seeing. And there's actually a few trials going on right now that are talking about who has the liability for that. And it's a really important issue to watch, especially if you have things where you have software running things for physical people in the world, and how that liability is going to shake out. I personally think it'll be a product liability type of inquiry where you go down the line between manufacturer to ultimate user, but we're going to be seeing how the judges and the law actually pans out with that. The second way is that we're seeing data as property come out, and that's for cyber negligence. And that's really important from a data breach perspective, because we were seeing a lot of hurdles to plaintiffs actually bringing these cases and being successful in them. And now what you're seeing is data as property. It gets over the economic loss doctrine in a lot of jurisdictions that were a major bar to a cyber negligence claim with regard to data breach. It also redefines what the damages are and brings that in as a new risk to data breach beyond regulatory and other lawsuits that you could see. And then we're also starting to see a rise of cases of cyber negligence related to social media and things that are being posted online, especially with regards to children. We're seeing congressional hearing on that. We're starting to see lawsuits being filed on that. There's a lot of bars to those lawsuits, and the law itself is really being worked out right now. But it's going to be really interesting to see, and very important for businesses that have any of these risks to understand how the liability is framing and working out.
And some of these issues, such as property, may have ramifications for insurance, which we won't deal with today. We'll cover that on another episode. But why do you think we're seeing more of these types of lawsuits?
A lot of reasons. In the world that we live in today, big data rules, and we all use it for different reasons. So we all carry around with us a tracking device called our cell phone that literally is with you. It actually, in several Supreme Court cases, believe it or not, the Supreme Court actually likened your cell phone to a part of your body. That is how intimately most people deal with their cell phone. So as you see kids and adults just carrying this little device with you around all the time, all it's doing is collecting data on you. And sometimes that data can be really sensitive. And you're also seeing a rise in cyber crime. So we're seeing people hacking into data. We're seeing custodians of our data not securing it properly and letting it go out there. And the way that that is affecting people has become more dynamic. So plaintiffs' attorneys, God bless them, they're really creative, and they're saying, all right, well, you know what, now this is a damage. I can bring a lawsuit on this. And people in the real world are actually either getting physically hurt or emotionally hurt, or in some other way hurt because their data is out there. So they're coming up with new and creative ways that are sticking. So there used to be a thing in law schools, Scott, I remember, you want to bring a lawsuit, you throw all your arguments against the wall and see what sticks. And this is what we're starting to see stick.
And plaintiffs are great at that. But, you know, when you were talking about cell phones, my wife used to complain that if she'd go on and look at an ad for something, she'd be inundated on social media with ads for the same thing. And then we noticed that even if she didn't go online and look, but we discussed something in the car, for example, she'd get those ads. The other day, I was just thinking about something and I'm not even talking about it. And an ad popped up. So we really are being spied on in one area or another. But I guess finally, what can a company do to attempt to avoid claims against it for negligence in the cyber and data context?
Well, it really all comes down to the legal need for the data and how you're securing it. And also being aware of your privacy obligations. So I always say cyber and privacy are two sides of the same coin. You can't have one without the other, but they do have different obligations and responsibilities. So it's important to understand that we have privacy regulation going live next year. So California leads the way right now with the California Consumer Privacy Act. And in January 2023, the California Privacy Rights Act replaces that and actually enhances not only the liabilities, but also the protections of data. Then we also have Utah, Connecticut, Virginia, and Colorado going live with their own versions of the CPRA as well too. Now, what does that mean for a business? That means if you are collecting data of consumers, so anyone that comes to your business wants to use your services or buy your products, you need a justification to collect their private data. You need to make sure that either you have their consent or some other legal reason to have it. Then you have to make sure you're protecting it with regards to either the privacy regulation you're under, or several states have data security rules regardless of privacy rules, and make sure you're protecting it correctly. And then a really important one, I actually just posted about this on LinkedIn, is data disposal. Making sure that when you don't have the legal justification anymore, you delete that information, it's not in your system. Those are great ways to make sure that you're not taking this data, securing it, and then if it's compromised, you don't have a legal justification for it, opening you up to these types of claims. You also want to be mindful of how you're using the data. Is it being used for artificial intelligence? Is it being sold to companies? Do consumers know about this? So it really comes down to consent, knowledge, and disposal when it's no longer necessary.
And so when you talk about disposal, is that something like bit bleaching?
It really comes down to making sure that if you need to delete the information, where it's deleted from. So if, say, you have a computer hard drive and you're going to retire that. So, you know, businesses need to retire their hardware, comes the next great bad model. When you're getting rid of that, you're sanitizing it and you're deleting all the information out and it's being securely deleted. That if you're sharing it with third-party vendors, you have within your contract that they will delete your information and then certify it to you. So if for some reason a third-party vendor doesn't do what they say, you actually have proof that they were complying with the contract and you can use that as a basis to sue them. So it really comes down to making sure that the data is no longer accessible, readable, or identifiable when you delete it, and making sure that anywhere that that data has been stored or shared has the same level of protection.
And you know what's interesting is there are some federal laws and regulations that touch on privacy issues in different contexts, but we don't have an overall federal privacy statute. And so you mentioned the various states enacting them. So companies have to be in the position of knowing when the different states' laws may apply to them and then complying with them. There's a lot of similarities between the statutes, but there are some differences, and it really is a compliance issue, isn't it?
Yes, 1,000%. And it's really important too, depending on the type of business, that you understand where your obligations lie. So if you're a business that's headquartered in New York, but you have customers all over the United States, you have to comply with those states where your customers live with regards to their data breach notification, their data sanitation or data disposal laws, and data security laws. So it's really important to get involved with a great counsel. I know one in particular that can help you outline and understand what your actual obligations are and make sure that your program is designed and compliant with those obligations. Because it's not just based where your business is located. If you're a consumer business in particular, it's where your consumers live.
And if I remember correctly, there actually was a federal bill pending in Congress, but that's going nowhere. And I think what prevented it from going forward was the fact that there was a provision that would preempt the various state statutes, and California in particular was objecting to that.
The federal privacy bill actually was a great start. There has been a lot of attempts to get a federal comprehensive privacy bill passed, not only to give protections to everyone in the United States, but also to deal with data breach notification, because we have 50 plus laws right now that require different notifications based on different levels of data breach, which can be really onerous for companies. The reason it failed is because California has the California Privacy Rights Act going live in January 2023. A really big and important element of the CPRA is that the California Privacy Protection Agency was created. And they've been working for the last year to not only develop and flesh out the regulations for the CPRA, but they're also the first regulatory body in the United States that's specifically going to be regulating privacy and data security issues. They have a tight budget, and they're out there to make sure that California privacy rights are enforced and protected. But because the majority of Silicon Valley has all of their terms and conditions in California law, the California Privacy Protection Agency is actually going to be a very significant regulatory enforcement body. This bill that was just killed in Congress would have actually obliterated them. They would have no longer existed because it would have fully preempted California law. Because the Speaker of the House is actually from California, she was acutely aware of this and made sure to try again.
And without getting political, there is a fundamental rule of government, which is you never ever get rid of an agency. So Annmarie, because you've done such a great job, and also because we've said this is a 3-part episode, we're going to have you back next time. And the attorney you were talking about that would be really good at helping people navigate through their data and cyber issues is you. And we will see you back here next time. And ladies and gentlemen, thank you for joining us this time on Hinshaw Insurance Law.
The information on our insurance law program is provided for general information purposes only. Nothing stated on the program constitutes legal advice or creates an attorney-client relationship. You should consult directly with an attorney of your choosing if you'd like to obtain any advice with respect to any claim, case, or matter. Any views expressed are those of the guests and are not necessarily the views of Hinshaw Culbertson or any of its clients. For information on past and upcoming programs, visit the Insurance and Reinsurance page on www.hinshawlaw.com and click on Multimedia.